Usually, when we think about a clock ticking, it's just this universal constant, right? Like 1 second is exactly 1 second.
Right, yeah, it doesn't change.
Exactly. You miss a flight, the plane is gone, the doors are closed, it's clean, it's binary. But in the legal world, you can literally ask a federal judge to just rewind the hands of the clock and legally pretend that yesterday never even happened.
Which is kind of mind-blowing when you think about it.
It really is. And that concept, like rewinding the clock, that sits right at the dead center of today's deep dive. We are welcoming you, yes, you listening right now, to join us as the third person in this conversation. We're going to thoroughly unpack a highly charged 10-page legal filing regarding the Epstein Files Transparency Act.
Yeah, and it's a dense one. So our source material today is an excerpt from a YouTube broadcast. It's by journalist and plaintiff Katie Phang on her channel, which is produced in partnership with the Midas Touch Network.
Right. But before we jump into the weeds here, we need to set some really crucial ground rules about exactly what we are and, just as importantly, what we are not doing today with this specific source material.
Yeah, this is a really important disclaimer for you. The broadcast we are unpacking contains some very strong, highly politically charged rhetoric.
Oh, absolutely.
And it's directed at some very prominent figures. Specifically, she targets Attorney General Todd Blanche, Donald Trump, and Senate Republicans.
So we want to be abundantly, perfectly clear with you here. We are not taking sides, like at all. We are not endorsing the viewpoints. We're not endorsing the tone or the allegations that are contained in this broadcast.
Right. Our sole objective today is to impartially report on this. We're just here to unpack the legal arguments and the ideas presented in Katie Phang's filing. That's it.
Yeah, we are strictly looking at the procedural machinery of this federal lawsuit. And the stakes of this machinery are, well, they're incredibly high.
They really are. I mean, this entire broadcast revolves around this looming court hearing in Washington, D.C., and it's before Judge Emmett Sullivan.
Right, on August 13th.
Exactly, August 13th at 1 p.m. Eastern Time. And Phang is basically demanding strict accountability, alleging that the Department of Justice is actively refusing to comply with federal law.
Okay, let's unpack this, because before we can even look at the highly sensitive documents at the heart of this case, we kind of have to understand the procedural chess match that is causing the delay in the first place, right?
Yeah, the delay is the whole trigger for this filing.
Right. So Attorney General Todd Blanche, he's the named defendant here, and he just straight up missed a hard deadline to answer Phang's lawsuit.
Right, which you really don't want to do in federal court. So in response to, missing that deadline, his legal team filed a motion. They requested a 60-day stay of all filing deadlines.
60 days is a long time.
It is. And they asked the court for a ruling called nunc pro tunc.
Nunc pro tunc, which sounds like a magic spell.
Yeah, it's Latin. It translates to now for then. And in federal civil procedure, it essentially functions as a retroactive mechanism.
Meaning they want a do-over.
Basically, yeah. It's a way for a court to allow an action to be treated as if it had been legitimately completed on an earlier date. So Blanche missed the deadline, and he's asking Judge Sullivan to, dial back the hands of time to excuse it.
And what's his excuse?
He's claiming what is legally termed excusable neglect. So his filing frames this missed deadline as just an inadvertent oversight, like a simple scheduling mistake by the DOJ.
Wow. I mean, that makes me think of trying to turn in a final term paper 2 weeks late. You walk up to the college professor and you're just like, hey, can you pretend I handed this in yesterday? It was just an inadvertent oversight, total excusable neglect.
Right. Yeah.
But here is the massive catch in Phang's filing. In that college analogy, you don't even provide the required doctor's note to prove why you missed it.
Exactly. And that doctor's note is crucial. According to the plaintiff, Blanche failed to file a sworn affidavit under penalty of perjury to support his excuse of neglect.
Wait, so they just said, whoops, without actually swearing to it?
Yeah, and that missing affidavit is a massive procedural vulnerability. I mean, in federal court, a lawyer cannot simply tell a judge through an unsworn brief that, their car broke down or they spilled coffee on a calendar.
Right, you have to prove it.
Yeah, the mechanics of civil procedure require you to swear to the specific factual grounds of your delay, in detail, under oath, and under penalty of perjury.
So without that sworn affidavit, the evidentiary standard for establishing good cause is just fundamentally absent. You haven't introduced any actual evidence of your excuse into the record.
Spot on. But Phang's filing goes much further than just pointing out the missing affidavit. I mean, she aggressively counters the entire premise of excusable neglect.
Oh yeah, she brings out the heavy hitters. She cites binding precedent from both the U.S. Supreme Court and the D.C. Circuit Court of Appeals. She points out that the highest courts have explicitly ruled that inadvertently overlooking a deadline simply does not constitute excusable neglect.
And this really points to the systemic reality of why federal courts are so unforgiving about deadlines. I mean, procedural rules aren't just bureaucratic red tape. They are the structural foundation of fairness and judicial economy.
Right, because if every attorney could just claim, oh, I forgot to pause federal litigation, the whole docket system would just collapse into chaos.
Exactly. Deadlines force parties to advance the litigation. They prevent endless stalling tactics. And Phang is leveraging this exact philosophy. Plus, she goes a step further and alleges that DOJ lawyers actually admitted to her legal team that this delay was not an accident at all.
Yeah, she alleges it was a highly calculated decision. According to her filing, she claims the DOJ intentionally wanted to wait until a separate preliminary injunction was resolved before answering her lawsuit.
Which is a huge accusation.
It is. And because they allegedly blew the deadline on purpose to manipulate the timeline, Phang is formally asserting that Blanche is now in default. She's saying he basically conceded her allegations by failing to legally answer them.
And claiming default is like the ultimate nuclear option in a civil lawsuit. If a judge declares a defendant truly in default, that defendant is stripped of their ability to contest the factual assertions of the complaint.
There's a massive power shift.
Oh, massive. It's the maximum penalty for failing to respect the procedural clock.
But, the DOJ's alleged defiance didn't just stop at procedural stalling tactics, which naturally begs the question, right? What exactly is the DOJ allegedly trying to delay?
Right, what's in the files?
Exactly. And that leads us straight into the specific, highly sensitive documents that Judge Sullivan ordered Blanche to produce. We know from the source that Judge Sullivan previously granted Phang's motion for a preliminary injunction.
And for anyone who follows these transparency and FOIA-style cases, crossing that threshold, establishing what's called Article 3 standing, is notoriously brutal.
It's super hard to do, right?
It's incredibly hard. Usually the government successfully argues the plaintiff hasn't suffered a specific enough, concrete injury just because the document is hidden and the case gets tossed out early. But by granting that preliminary injunction, Judge Sullivan already cleared her biggest hurdle.
He basically confirmed she has Article 3 standing.
Yes, he formally recognized her standing, essentially handing her the keys to force discovery. And he generated a very specific mandate for the DOJ.
Right, and that mandate ordered Blanche to complete 5 specific tasks by July 2nd, which, according to Phang, he just blew right past.
Yeah, didn't happen.
He allegedly failed to initiate the review and translation of foreign language materials. And crucially, he failed to provide a formal redaction log. Instead of this detailed log, he just offered a generic summary.
And the mechanical difference between a formal redaction log, which is often called a Vaughn index in federal transparency litigation, and a simple summary is night and day.
How so?
Well, a Vaughn index doesn't just list documents, right? It mechanically forces the DOJ to match every single blacked-out sentence to a specific statutory exemption code. It forces the government to defend their secrecy line by line.
Oh, so they can't just hide behind a blanket claim of privacy or national security.
Exactly. A summary completely lacks that granular, legally binding justification. It leaves the plaintiff entirely blind to why the information is actually being withheld.
Okay, but wait. If a federal judge explicitly orders a detailed redaction log under a specific Transparency Act, how can the DOJ just offer a summary? Isn't that a direct defiance of a court order?
Well, what's fascinating here is the inherent tension between standard government redaction practices and the aggressive requirements of a law like the Epstein Files Transparency Act.
Right, because they usually just take forever.
Exactly. Historically, the DOJ operates within this deeply entrenched culture of extreme caution. Standard information requests take years. Their default institutional posture is always to withhold information to protect ongoing operations or privacy.
But this act is different.
It's very different. The Epstein Files Transparency Act is a specialized mandate from Congress, explicitly designed to pierce through that standard bureaucratic shield. So when the DOJ offers a summary, they're reflexively leaning on their traditional, decades-old playbook of institutional friction.
While the plaintiff is standing there demanding strict adherence to this new demanding law.
Exactly.
And man, that friction hits a total boiling point when you look at the most explosive part of what they're allegedly withholding. I mean, we aren't just talking about foreign translations here.
No, the content is deeply disturbing.
Phang's filing claims that Blanche specifically withheld handwritten FBI notes from 4 interviews with a victim. The filing outlines that this victim alleges that when she was 13 years old, she was sexually abused and physically battered by convicted felon Donald Trump.
And those incredibly severe allegations are detailed directly in the plaintiff's filing. I mean, they serve as the raw fuel for this entire litigation.
It really puts it in perspective.
It does. It perfectly illustrates why this procedural chess match over deadlines and Vaughn indices is being so bitterly contested. I mean, this fight over a simple redaction log is actually a fight over alleged documentation of severe, high-level abuse.
But the DOJ's alleged non-compliance wasn't limited to just what they withheld from Phang. According to the filing, it extends to what they allegedly refused to show the judge himself behind closed doors.
Right, which brings us to an entirely different legal mechanism, the in-camera review.
Yeah, and an in-camera review is basically one of the most critical checks and balances a federal judge possesses, right?
Absolutely. When a government agency claims they have to redact a document for privacy or security, the judge doesn't just take their word for it. The separation of powers demands verification.
Show your work.
Exactly.
Right.
The judge orders the agency to bring the unredacted raw materials into their private chambers. That's what in-camera means, so the judge can independently verify if the redactions are legitimate.
So Judge Sullivan ordered Blanche to bring these unredacted materials to his chambers. But according to Phang's filing, Blanche allegedly failed to produce corroborating documentation for 2 very specific emails.
Yeah, and Blanche's argument was that these redactions were necessary to protect the privacy of third parties, meaning not victims, but other people just mentioned in the investigative files.
Right, but Phang reveals that these withheld emails involve individuals discussing an affinity for torture videos and expressing that sexual relations with 14 and 15-year-old girls are acceptable.
Which is horrifying. And the legal distinction between a victim and a third party in transparency law is incredibly complex here. I mean, protecting a victim's identity is an ironclad legal standard. But shielding a third party gets incredibly messy when you balance it against the public's right to know.
Especially given the disturbing content. And Phang argues that the Epstein Files Transparency Act explicitly prohibits the DOJ from withholding information simply to spare these third parties from humiliation, embarrassment, or public identification.
Right. The precise statutory language of the Act is the fulcrum here. Traditional privacy exemptions often grant the government wide latitude to shield citizens from unwarranted public embarrassment.
Even if they aren't charged with a crime.
Exactly. But Phang's legal theory hinges on the argument that Congress wrote this specific Transparency Act to intentionally strip away that standard embarrassment protection, basically determining that the extraordinary public interest supersedes a third party's right to privacy here.
So what does this all mean? I mean, it really brings us back to what I'd call trust me bro lawyering. It's exactly like a math teacher looking at a student and saying, hey, you gave me the final answer on the test, but you have to show your work.
And Judge Sullivan is the math teacher.
Yes, he is demanding the unredacted emails to verify the work. But according to the filing, Blanche allegedly walked into the judge's chambers completely empty-handed for those specific documents.
And in federal court, walking in without your homework during an in-camera review means the judge can automatically rule that your redactions are invalid. The math teacher fails you on the spot.
And the documents become public.
Right. And if we connect this to the bigger picture, this represents the absolute bleeding edge of transparency law. We are watching a real-time stress test of the boundary between a private citizen's right to privacy and the public's demand for accountability.
Do you lose your right to privacy just because your highly disturbing private communications were swept up in a federal investigation?
Under normal circumstances, the DOJ's reflex is to protect that privacy at all costs. But the plaintiff is arguing that Congress built a legal bulldozer to override that exact defense.
It is an intensely serious, high-stakes legal battlefront. And yet, here's where it gets really interesting. Right in the middle of breaking down all these federal rules of civil procedure and these severe abuse allegations, Katie Phang executes this sudden, incredibly jarring pivot in her broadcast.
Yeah, a direct, seamless transition into a sponsor read.
Right there on the YouTube broadcast. She pivots flawlessly into an ad for a company called Honeylove.
I remember watching that and just thinking, wow, what a shift.
It's wild. She details how it's an independent, female-founded brand created by a woman named Betsy. She highlights this wireless crossover bra that uses bonding technology instead of underwires. She even gives out a 20% discount code, honeylove.com/Phang, right to her viewers.
And hearing this as a listener is just a massive juxtaposition.
Totally. You are shifting from federal court defiance and severe statutory exemptions straight into direct-to-consumer shapewear. I mean, what does this tell us about the modern reality of the media landscape?
It reveals the unfiltered economics of independent journalism today. I mean, taking on the Department of Justice in federal court is astronomically expensive.
Oh, I can't even imagine the legal bills.
They're huge. Drafting these filings, fighting over Vaughn indices, litigating injunctions, it requires thousands of hours of specialized legal work. And historically, only massive corporate media conglomerates had the legal budgets to wage those multi-year wars.
Right, the legacy television networks, giant print newspapers.
Exactly. But that traditional dynamic has completely fractured. Those massive corporate safety nets are largely gone. Today, independent creators and journalists like Phang are the ones pushing the bleeding edge of these FOIA fights.
But they don't have a massive corporate legal department bankrolling them.
No, they don't. So to wage a war against the DOJ, independent journalists are forced to rely entirely on direct audience monetization.
Meaning that this massive federal legal fight for transparency is literally being crowdfunded by ad reads, YouTube subscriptions, and discount codes for wireless bras.
Yeah. The sponsor read might feel jarring when you're engrossed in heavy constitutional questions, but that specific ad read is the literal financial engine allowing the lawsuit to exist in the first place.
It's wild to think about.
It forces independent journalists to simultaneously act as high-level legal crusaders and direct-to-consumer marketers. I mean, if you cannot sell the shapewear, you cannot afford the lawyer to demand the redaction log.
It is a crazy reality to process, but it makes complete mechanical sense when you lay out the brutal economics of federal litigation. You simply cannot rattle the cages of the DOJ for free.
You absolutely cannot. And this brings us back to the immediate pressing reality of this specific lawsuit.
Yeah.
As we wrap up today's deep dive, the urgency of the moment just cannot be overstated.
Right. Everything is converging.
Exactly.
Yep.
All of this highly technical procedural maneuvering, the missing affidavits, the withheld foreign translations, the summaries instead of logs, the allegedly empty-handed in-camera reviews, it all collides at that status hearing before Judge Emmett Sullivan.
On August 13th at 1 p.m. Eastern.
Yes.
And the central unresolved issue that everyone is watching for is exactly how much of Blanche's alleged noncompliance Judge Sullivan is actually going to tolerate. Like, at what point does a federal judge look at the totality of the missed deadlines and missing documents, declare that the procedural clock has run out, and finally lower the boom?
Right. Will the judge enforce a strict, aggressive interpretation of the Epstein Files Transparency Act, basically failing the government for not showing its work? Or will the DOJ's deeply entrenched methods of slow, highly cautious procedural friction win the day?
It's going to be fascinating to watch. But as we close this deep dive, we want to briefly remind you, our listener, one more time about the boundaries of what we've explored today.
Right. Very important.
We have been strictly examining the legal framework, the structural mechanics, and the arguments explicitly presented in Katie Phang's court filing. We have not taken any political sides regarding the Department of Justice, the Attorney General, or any of the political figures mentioned in the source material.
Our goal was simply to give you the clearest possible picture of the legal chess match happening right now.
Exactly.
And as you process the mechanics of this case moving forward, I want to leave you with a larger, lingering question. Something that builds on the structural tension we've discussed today, but looking at the whole system of government accountability.
What's the question?
If a specialized, highly targeted law, like the Epstein Files Transparency Act, a law explicitly designed by Congress to force rapid disclosure, still results in this kind of prolonged, grinding procedural warfare over basic redaction logs and missed deadlines. How effective can any transparency legislation truly be when it goes up against the entrenched bureaucracy of the federal government?
Yeah. It really makes you wonder who actually controls the hands of the clock. Thank you so much for joining us for this deep dive. We'll see you next time.